C-4. Numéro 3, C-4.
Senator Cormier.
Senator Cormier. Thank you, Mr. Speaker. Honourable Senators, I move that the second reading of this bill. It is moved by the Honourable Senator Cormier, seconded by the Honourable Senator Lévy-Deschênes, that the bill be read a second time. On debate, Senator Cormier. Thank you, Mr. Speaker. Colleagues, it is with emotion that I rise today to begin debate on second reading of Bill C-4, which proposes to ban conversion therapy, an abhorrent practice that stigmatizes and discriminates against the lesbian, gay, bisexual, transgender, queer, and two-spirit communities. Practices that are harmful to the people who are subjected to them and harmful to society in general. Pseudotherapies that perpetuate stereotypes and myths that have no place in Canadian society. Although these interventions are still often referred to as conversion therapy, they are clearly not therapeutic. They start from the premise that LGBTQ2+ people can and should change, and they often occur in insidious forms. While some people still doubt the presence of these deleterious practices in our country, results from the 2019-2020 Sex in the Present survey indicate that approximately 10% of sexual minority men who responded to the survey were subjected to conversion therapy in Canada. The survey also found that exposure to these destructive practices was higher among non-binary and transgender people, among immigrants, youth, and people with low incomes, too. In the majority of cases, the exposure to conversion therapy was in a religious setting, and in the remaining cases, it was in a healthcare setting. Colleagues, conversion therapy is real, harmful, and found in our country. For decades, the LGBTQ+ communities, and especially the survivors of these dangerous acts, have been campaigning with determination and courage to stop these senseless practices. The time has finally come to respond and protect them, adults and children alike. By strengthening the protections proposed in the former Bill C-6, which was introduced in the previous Parliament, Bill C-4 sends a strong and necessary message. No form of conversion therapy will be tolerated for the Canadian public. I would be remiss if I did not mention the strong emotion felt by many Canadians when this bill was passed unanimously in the other place on December 1st. While we may have been surprised by the speed of its passage, the expression of solidarity speaks volumes about the values we hold dear as Canadians, values of equality, dignity, and respect for all, with full recognition of our differences. Bill C-4 is part of a long process of recognizing the rights of LGBTQ+ people in our country. From the partial decriminalization of homosexuality in 1969 to the passage of Bill C-23 in 2000, which gave same-sex couples the same social and tax benefits as heterosexuals in common law relationships. From the enactment of the Civil Marriage Act, allowing same-sex couples to marry across Canada in 2005, to the passage of Bill C-16 in 2017, which added gender identity and gender expression to the prohibited grounds of discrimination under the Canadian Human Rights Act, and up to the passage in 2018 of Bill C-66, which I had the privilege of sponsoring here in the Senate, which seeks to expunge historically unjust convictions against people in the LGBTQ+ communities. Our country has taken important steps towards respecting the fundamental rights and dignities of all citizens. It took several legislative proposals to arrive at this bill, and in this regard, I would like to salute our former colleague, retired Senator Serge Royal, who introduced Bill S-260 in this House in the 42nd Parliament, raising awareness among his parliamentary colleagues. Today, it is up to us to continue that work by taking a careful and rigorous second look at Bill C-4, by being empathetic, and by working diligently to ensure that all Canadians, regardless of age, sexual orientation, gender identity, or expression, can love the person of their choice, be themselves in freedom, and live as they choose in safety.
Bill C-4 is specifically designed to protect the dignity and equality of LGBTQ2+ Canadians by ending conversion therapy in Canada. It would do so by criminalizing conversion therapy in all settings and regardless of age or consent. Although former Bill C-6 would have comprehensively protected children, it would only have protected adults from forced conversion therapy and prohibited the commercialization of the practice. Bill C-4's comprehensive approach is intended to target the different types of harms that conversion therapy poses. These harms can manifest themselves at the individual level, including for persons who had consented to undergo conversion practices. The research about the harms of conversion therapy stemming from Canada and the US clearly identifies its devastating outcomes for individuals, including feelings of shame, isolation, anxiety, depression, problematic substance use, and suicidality. For example, the 2019 American Trevor Project National Survey on LGBTQ youth mental health found that 57% of transgender and non-binary youth who have undergone conversion therapy report a suicide attempt in the last year. Canadian and international professional associations have denounced these practices. To name a few, the World Health Organization, the United Nations Committee Against Torture, the Committee on the Rights of the Child, the Human Rights Committee, the Canadian Psychiatric Association, the Canadian Psychological Association, l'Ordre professionnel des sexologues du Québec, and the Canadian Association of Social Workers were clear about these practices. They are dangerous. I would also like to bring to your attention the testimonies of the courageous individuals who appeared in the other place during the study of the former Bill C-6. Their words are revealing. They said that the harms of conversion therapy are serious, regardless of age or consent, and that the best way to protect against them is to totally ban the practice. We need to listen to them, colleagues. There is ample evidence of the harmful effects on victims of conversion therapy. But let us not forget that the effects of these discriminatory practices are also manifested on a larger societal scale. Indeed, the very existence of conversion therapy practices is harmful to the dignity and equality of LGBTQ2+ communities because these practices posit that there is something fundamentally wrong with the LGBTQ2+ individual and that they should change who they are, who they love, and how they express themselves to arrive at a sexual orientation, gender identity, or gender expression that some believe is preferable.
This premise is inherently discriminatory and harmful, not only to LGBTQ+ communities, but to society in general, as we are all diminished by practices that undermine the equality and dignity of every member of our society. Thus, one way to end practices that are based on such hurtful and discriminatory premises is to ban them outright, regardless of an individual's consent. And this is not an unusual or inappropriate rule for the criminal law. Under its jurisdiction, the federal government can effectively criminalize a legitimate public health harm. In this case, the evidence is overwhelming. Conversion therapies are profoundly harmful. The prohibition of conversion therapy when the recipient is a consenting adult naturally raises questions about compliance with the Canadian Charter of Rights and Freedoms. The idea of conversion therapy may be linked to religious beliefs for some, and others may believe that they should have the freedom to choose interventions that they feel are beneficial to them. The well-established harms, however, as well as the prevalence of conversion therapy practices among vulnerable members of an already marginalized community, support the decision for a complete ban on these practices.
I would add that we cannot ignore the notable movement on the international scene that points to an emerging consensus about conversion therapy's harms and legal responses to prohibit it, such as those proposed in this bill. The UN Independent Expert on Protection Against Violence and Discrimination based on Sexual Orientation and Gender Identity released his report entitled Practices of So-Called Conversion Therapy in the spring of 2020. That report found that the best way to address conversion therapy's harms is to ban the practice from being advertised and carry out in all settings, whether public or private, including education, community, or religious settings. In particular, the UN Independent Experts Report describes the practices of conversion therapy as deeply harmful interventions that rely on the medically false idea that LGBT and other gender diverse persons are sick. The report also notes that these practices inflict severe pain and suffering and result in long-lasting psychological and physical damage. Colleagues, let me quote two passages from this report. Quote, all practices attempting conversion are inherently humiliating, demeaning, and discriminatory. The combined effects of feeling powerless and extreme humiliation generate profound feelings of shame, guilt, self-disgust, and worthlessness, which can result in a damaged self-concept and enduring personality changes. These practices also violate the prohibition of torture and ill treatment, since they are a point of departure in the belief that sexually diverse or gender diverse persons are somehow inferior, morally, spiritually, or physically than their heterosexual and cisgender siblings, and must modify their orientation or identity to remedy that inferiority. Therefore, any means and mechanisms that treat LGBT persons as lesser human beings are degrading by their very definition and may amount to torture depending on the circumstances, namely the severity of physical and mental pain and suffering inflicted, end of quote.
In addition to the UN Independent Expert Report, several countries are considering or have already adopted mechanisms to ban conversion therapy. The territory of the Australian capital has recently passed criminal legislation to prohibit the practice of conversion therapy on minors and persons with diminished decision-making capacity. A bill is currently under review in France, which proposes to ban conversion therapy practices that have an impact on a person's mental or physical health. Legislation was introduced in New Zealand this summer, proposing to create criminal offences that would prohibit the provision of conversion therapy to minors or persons who lack decision-making capacity, and the provision of conversion therapy to anyone if it causes serious harm, which is defined as any physical, psychological, or emotional harm that seriously and adversely affects the health, safety, or well-being of the individual. Consent would not be a defence in any of these proposed offences. The British government, meanwhile, is consulting the public on a proposal to criminalize certain aspects of conversion therapy, including when it takes the form of talk therapy, in addition to physical acts performed in the name of conversion therapy. Finally, it will be recalled that Malta was the first state to criminalize the provision of conversion therapy to vulnerable persons, including persons under the age of 16. In Canada, provinces, one territory, and several municipalities have stepped up to the plate in their respective jurisdictions. Yukon, Ontario, Quebec, Nova Scotia, and Prince Edward Island have passed legislation clarifying that conversion therapy is not an insured health service and prohibiting healthcare professionals, and in some cases anyone else, from providing treatment in specific circumstances. Manitoba has a policy statement against these practices. Municipalities such as Vancouver, Calgary, Edmonton, St. Albert, Lethbridge, Saskatoon, Regina, Kingston, and many others have responded by banning businesses from offering conversion therapy within their boundaries. Colleagues, these Canadian and international developments build momentum for a ban on conversion therapy. On the one hand, they send a clear signal that our country is more than ready to put an end to such practices, and on the other hand, that Bill's C-4 approach of using criminal law to completely ban this harmful practice in all settings and disciplines is neither unique nor inappropriate.
I would not like to discuss the definition of conversion therapy included in Bill C-4, since it impacts the scope of all four of the bill's proposed offenses. Bill C-4 would define conversion therapy as a practice, service, or treatment, which I will collectively refer to as an intervention, that is designed to achieve one of the 6 prohibited objectives. These are to change a person's sexual orientation to heterosexual, to change a person's gender identity to cisgender, to change a person's gender expression to conform with the sex assigned at birth, to repress or reduce a person's non-heterosexual attraction or sexual behavior, to repress a person's non-cisgender gender identity, or to repress or reduce a person's gender expression that does not conform with the sex assigned at birth. Specifying that interventions designed to repress or reduce non-heteronormative or non-cisnormative feelings or behavior are conversion therapy, responds to concerns that conversion therapy providers could seek to avoid criminal liability by hiding behind a thinly veiled argument that their efforts are intended to reduce or repress certain forms of feeling or expression, not change who a person is. The definition also includes a very important for greater certainty clause, which clarifies that intervention aimed at helping a person explore or develop their integrated personal identity are not conversion therapy if they are not based on the assumption that a particular sexual orientation, gender identity, or gender expression is to be preferred over another. Again, this clause protects legitimate supportive practices, service and treatments, and not conversion therapy practices purporting to help an individual change a fundamental aspect of their identity under the guise of identity development or reconciliation therapy. This clause also clarifies that gender transition interventions, those steps that would be chosen and taken by a person to live more in accord with their gender identity or expression, are not conversion therapies. In the previous Parliament, concerns were expressed that former Bill C-6 definition, which is substantively the same as that proposed by Bill C-4, was vague and may capture mere conversations about sexual orientation, gender identity, or gender expression. I would like to address this concern directly and explain why I do not share it. The bill's definition contains two separate components, both of which must be met. First, the conduct must constitute an intervention or in the precise words of the bill, a practice, treatment, or service. These terms have a clear literal meaning, which implies an established, structured, or formalized intervention that is generally offered to the public or a segment of the public. Second, an intervention must also be designed to achieve one of the definition's prohibited purposes, that is to impose heteronormative or cisnormative standards on the individual subject to it. This approach to defining conversion therapy is entirely appropriate and consistent with the bill's important objectives of protecting LGBTQ2+ persons from interventions that discriminate against them. En bref, la définition.
In short, the definition is carefully tailored to target only those interventions that cause harm, because they assume that heteronormative and cisnormative identities or expressions are preferable to others. Bill C-4 would also protect all Canadians from the commercialization of the practice by prohibiting the profiting from, promotion, or advertising of conversion therapy. It would also provide additional protection for children by targeting anyone who takes a child out of Canada for conversion therapy purposes. In plain language, colleagues, the bill amends the criminal code, in particular to create the following offenses: anyone who knowingly causes another person to undergo conversion therapy, including providing conversion therapy; anyone who knowingly promotes conversion therapy or advertises conversion therapy; anyone who receives a material benefit, including a pecuniary benefit that he or she knows is or was obtained directly or indirectly from the provision of conversion therapies; and anyone who smuggles a child under the age of 18 out of the country for conversion therapy is committing an offense. In short, what Bill C-4 proposes to prohibit is carefully crafted to encompass only those harmful practices that seek to alter a person's identity based on a discriminatory premise that certain sexual orientations, gender identities, and expressions are less desirable than others. It does not include supportive interventions or the mere expression of beliefs about sexual orientation, gender identity, or expression. Furthermore, the proposed approach in no way prevents individuals from making their own choices about how to express their gender identity or sexual orientation. It's only concerned with interventions aimed at changing a person's identity. Bill C-4's approach may seem bold, but a comprehensive ban is the best way to achieve the important goal of protecting LGBTQ2+ individuals and communities from the harm and discrimination that results from conversion therapy. Colleagues, I'm personally proud that Canada is showing leadership on this issue. Indeed, this bill would put Canada at the forefront of the international community. Passage of this bill in Canada will be critical for all Canadians, but when we think of the victims of these practices around the world, we can easily see the impact it'll have on the international stage.
Value diversity. We know that. We want a country that respects the differences between us. That is the very aspect of Canada that defines us. In Canada, everyone should feel safe to be who they are. I know we are all committed to realizing Bill C-4's overarching objective of protecting the dignity and equality of all Canadians. The bill reflects our fundamental Canadian values as articulated in our Charter of Rights and Freedom. And I know we all agree that Canada should be a place where diversity is celebrated, not revealed, a place where everyone can live in equality and freedom.
Colleagues, this is not an opposition bill. It's not about making judgments about the religious beliefs of individuals. It's not about preventing parents who care about their kids' health and happiness from having conversations with them. Nor is it intended to prohibit teachers from discussing sexual orientation and gender identity with their students.
It's about, first and foremost, the full recognition of the fundamental rights of all people to live in dignity. Having researched and investigated this issue and thinking of the more than 47,000 men who have undergone conversion therapy in Canada, as stated in the above-mentioned Sex in the Present report, I look forward to our consideration and passage of Bill C-4 in a timely fashion. In closing, on a more personal note, thankfully, there are many people in Canada who have not had to go through conversion therapy. Individuals have not had to make these heartbreaking choices because of the people around them. In the process of coming to terms with one's sexual orientation or gender identity, there are dark and tormented periods. The urge to stop suffering is frequent and pervasive. At the age of 19, I experienced this distress, which could have led me to commit a fatal act or to undergo conversion therapy. The inner turmoil was too great and the fear of rejection too deep. Fortunately, though, thanks to my family and my community, thanks to my friends who were there without judgment, simply accompanying me in my process of acceptance, I stand before you today and I'm filled with gratitude to those who have helped me. Today, colleagues, my thoughts are with the victims of conversion therapy, those who survived and have the courage to testify, and those who unfortunately did not survive these horrible, discriminatory practices. As legislators, let's make sure that all those who are faced with these same heartbreaking choices can live fully, and through Bill C-4, let's ensure that these people are not steered in directions that have disastrous impacts on them. With International Human Rights Day just a few days away, I'd invite us to work together, as we are well able to do, to study and pass Bill C-4 as soon as possible so that people living in this country can be protected and loved for who they are. They are human beings who want nothing more than to live, to love, to be happy, and to contribute to our society. Thank you.
On débat, Senatrice Jaffer.
Honourable Senators, I rise today to speak on second reading of Bill C-4, amending the Criminal Code, banning conversion therapy. I want to begin by especially thanking Senator Cormier, the sponsor of this bill. He has worked very hard on the former Bill C-6 and now C-4. Merci, Senator Cormier.
Thank you, Senator Cormier.
He and his office, including Mary-Lise Gosselin, have worked exceptionally hard on this bill to ensure that C-4's vision is realized. And we'll all see that. Thank you for your dedication. I also want to thank my own team, including Madison Pate Green, for all her hard work and support. Honourable Senators, like many of you, I have received countless emails and calls from Canadians who have views on all sides of this bill. I believe we need to ensure all sides are heard in this debate. One email I received pleaded with me, and I quote, if passed into law, parents risk 5 years in jail for asking a counselor to help them work through gender dysphoria issues with their child. If this bill is passed, it will prevent members of the LGBTQ+ community from getting the help they desire. During debate on Bill C-6, this bill's predecessor, the House of Commons Standing Committee on Justice and Human Rights, heard testimony from the LGBTQ+ Canadians about how counseling helped them understand their identity and reduce their non-heterosexual sexual behavior. Parents, teachers, pastors should be able to play a supportive role in the life of a young person struggling with gender identity. Harmful forms of conversion therapy should be banned. But Bill C-4 is too broad and wrongly includes Christian counseling and other support services in the ban. Close quotations. Senators, we just heard from Senator Cormier, and we will hear from others. That will make Canadians realize that conversations is not what this bill is about. It is about harming individuals. And that I believe, Senators, there is still doubt in the mind of some Canadians that this bill prevents conversations. And they only have to hear what Senator Cormier said. And I'm sure when the minister comes to the committee, it'll give them assurance that it is not about banning conversations between parents, between counselors. It is about harming an individual. Just like we did with medical aid in dying, we have a responsibility to listen to all Canadians across our country and really consider what they are telling us. Given this is second reading, I will continue listening to all the speeches as this debate continues. Many Canadians believe that conversion therapy is rooted in the idea that to identify as anything other than straight or cisgender, meaning a person whose personal and gender identity are the same as their birth sex, is mental illness. There are lots of studies that tell us children who are forced into unaccepting and thus harmful environments will in turn often experience detrimental mental health. This can manifest in many ways, such as symptoms of anxiety, depression, and in the worst and most traumatizing circumstances, death by suicide. David Kintz is a PhD student in social and behavioral health sciences at the University of Toronto. And he very courageously shared his story, and I quote, "I am a survivor of conversion therapy, and I know firsthand how harmful it is. At 16, I decided to self-enroll in conversion therapy out of a desire to be, in quotation marks, straight and act in more masculine ways. My formative years were filled with invalidating experiences and heteronormative pressures that led me to the point of thinking that being queer was something that was incompatible with living in our society, forcing me to want to consider changing, or worse, take my own life. I am telling my story because I believe no other youth should go through what I and so many others experienced. Conversion therapy should be criminalized. I am now a health researcher, an advocate of LGBTQ+ equity, working on a project at Simon Fraser University led by Travis Salve. The study hopes to understand experiences of survivors and to recommend healing methods." Close quotations. Echoing David's sentiments, in 2012, the Pan American Health Organization found no medical justification in the practice that it is threatened the health and human rights of those who endure it. In 2016, the World Psychiatric Association reportedly found no sound scientific evidence that innate sexual orientation can be changed. Further, the independent Forsanic expert group of health specialists regard conversion therapy as deceptive, false advertising, and fraud. Less than 25% of Canadians believe that you can actively convert an LGBTQ+ a person to become heterosexual through psychological or spiritual intervention. Support in banning conversion therapy across Canada was highest amongst women, 62%, and those aged 18 to 31, 64%. In 2019, an opinion poll highlighted that a majority of Canadians, 3 in 5, are against conversion therapy. That same year, the current federal government publicly called upon all provinces and territories to ban this torturous practice. Recently, a UN envoy cited a global survey that suggests 4 out of 5 people who endure conversion therapy were younger than 25, roughly half of whom were under the age of 18. Honorable Senators, I now want to read to you parts of conversion therapy which are far too often swept under the rug of paralyzing shame and unhealed trauma. Beatings, rape, forced nudity, forced feeding or food deprivation, isolation and confinement, forced medication, verbal abuse, humiliation. According to Article 37A of the United Nations Convention on the Rights of the Child, no child should be subjected to torture or other cruel, inhumane, and degrading treatment or punishment. Neither capital punishment nor life imprisonment without the possibility of release shall be imposed for offenses committed by persons below 18 years of age. Honorable Senators, I know that conversion therapy strips a person of their most basic and intrinsic liberty to be free from persecution, free from hatred, free to be themselves without fear. Senators, I want to share with you that when we went through the MAID hearings, they were long. We had all kinds of people who spoke to us on different points of view of that bill. When I travel across the country, even now, I hear from people who are still not sure, but they were at our hearings and they said, at least they were heard. I genuinely believe that in our country today, we need conversations. We need to understand the other points of view of another person. If we shut down debate, we say we don't care how you feel. If we open the door, even if we don't agree with them, we will make them feel that we heard them. That's why today, Senators, I stand in front of you at second reading and ask you to consider sending this bill to committee so that those people who feel that their point of view should be heard will be heard. I thank you for your attention. Thank you, Senators.
On debate, Senator Musakos.
Mr. Speaker? Thank you. Yes. Mr. Speaker, C-4 is a bill that has been turned into a controversial political football, unfortunately. I want to rise, colleagues, to point out that in the last Parliament, we received C-4, of course, here on the eve of before the government adjourning for an unnecessary election. And the government on a number of occasions has said that the LGBTQ2 community is very important to them. So important that, of course, 6 years went by, and of course, this bill was not again initiated until it was tabled in the House again at midnight before the Parliament rose for the general election. I want to say this, that no communities, not the LGBTQ, not any Canadians deserve to be treated as political props or for political expediency. That's not the Canadian way. I can say this, that the community has been heard. It was heard by the House of Commons, and of course, we saw the House of Commons do the right thing a number of days ago and pass this piece of legislation unanimously. And they did so because they thought it was in the national interest to do so. Colleagues, we already have government business before committees in this place. We have only a week left before we traditionally rise for the break. We have C3 that's already in a pre-study before the Committee of Legal Affairs and Constitutional Affairs. There's a series of PMBs, as I mentioned earlier, and motions that many parliamentarians in this chamber want to get to. I think we have to get to the reflex in this institution that when something is in the universal interest, public interest, that we should not create unnecessary duplication and engage into unnecessary debates. And furthermore, I don't think, even on an issue like any issue, we should be using it as a political prop to divide, to make it divisive. We should be, as an institution, working to bring all Canadians together. And therefore, that's why I am proposing, colleagues, with the consent of the Chamber, that, honourable senators, I ask for leave that the bill be read a second time and then be deemed ready a third time and passed by this Chamber. Thank you, colleagues.
Senators, it was moved by Senator Saco, seconded by Senator Carignan, that leave be granted, that the bill be read a second time and then deemed to be read a third time. If you are opposed to leave, please say no. Hearing no negatives, I move.
Second reading of this bill. Deuxième lecture de ce projet de loi. Third reading of this bill. Troisième lecture de ce projet de loi.
It is ordered that a message be sent to the House of Commons to acquaint the House that the Senate has passed this bill without amendment.
Government motions, motion du gouvernement. Number 1, numéro 1.
Stand.
Number 7, numéro 7.
Senator Gold.
Thank you, Your Honour. Honourable Senators, I move the motion standing in my name.
It is moved by Senator Gold, seconded by Senator Gagné, that notwithstanding any provision of the rules or unusual practice, dispense? Thank you. Are senators ready for the question? Debate. Senator Gold, want to speak?
Thank you, Your Honour. Honourable Senators, I rise today to speak briefly to Government Motion Number 7, which will re-establish a process for a minister to participate in the Senate's question period every second Senate sitting week. While I deeply regret that this motion will relieve me from time to time of the pleasure of attempting to answer your questions, I am most happy to propose it because it constitutes yet another step in restoring a sense of normalcy to the Senate's operations. I'm also pleased to propose this motion because it establishes a new format for ministerial question period that is based upon meaningful consultation and agreement with the leadership of all groups, and informed by the Senate's extensive experience hosting ministers in this chamber over the course of 2 parliaments. So while this may be a government motion, as is so often the case, it bears the fingerprints of all groups. For example, the Progressive Senators group proposed that the motion specify that ministerial question period be held every second week in order to ensure some regularity for minister question period while maintaining some flexibility on the specific dates. In addition, it was quite important to the opposition in the Senate that the questions of senators and the answers of ministers be subject to time constraints.